Sir, you need to stop resisting and get on the ground.
I'm not resisting. I'm standing still. My hands are visible.
You're being belligerent. Get on the ground, now.
Officer, I'm a sitting federal judge.
I don't care who you think you are. On the ground.
My hands are empty. I'm not a threat.
Every second of this violates established law.
Officer Mark Reynolds had absolutely no idea that the gray-haired man standing beside the silver Lexus wasn't afraid, wasn't confused, and wasn't bluffing. He also had no idea that the man he was about to detain had spent more than 3 decades inside federal courtrooms shaping cases that defined how police authority is limited by the Constitution. The man stood still, hands visible, grocery bags already loaded into the trunk, keys resting openly in his palm. "Sir, stop resisting and get on the ground," Reynolds ordered. "I'm standing still," the man replied calmly. "My hands are visible." "You're being belligerent," Reynolds said. "Get down now." "Officer, I'm not resisting anything," the man answered evenly. "I'm an elderly man loading groceries into my own vehicle." Reynolds stepped closer, his hand hovering near his weapon. "I don't care who you think you are. Hands behind your back." "My hands are empty," the man said. "I'm not a threat, and your body camera is recording this entire interaction." Reynolds didn't respond. "Understand this," the man continued, his voice controlled and deliberate. "Every second of what you're doing is being recorded. Your body cam, the parking lot security cameras, and civilian phones nearby. And what you're doing right now violates clearly established law." Reynolds still didn't know the man's name was Samuel Whitaker, or that he had spent 27 years as a federal civil rights attorney arguing unlawful search, excessive force, and false arrest cases. He didn't know that Whitaker had cross-examined officers who lied under oath, or that his legal arguments had been cited by appellate courts across multiple states. All Reynolds saw was an older black man near an expensive car, and that assumption was about to change everything. Samuel Whitaker turned slowly, making sure every movement was deliberate and visible, habits built from decades of watching police encounters dissected in courtrooms. "Is there a problem, officer?" he asked. "Step away from the vehicle and show me some identification," Reynolds replied, his voice sharp and practiced. Whitaker recognized the shift immediately. This wasn't casual conversation, it was a detention. "Before I do that," Whitaker said calmly, "what reasonable suspicion do you have that I'm engaged in criminal activity?" Reynolds' expression tightened. "I'm responding to a suspicious person call." "A suspicious person doing what?" Whitaker asked. "Loading groceries?" Reynolds shifted his stance. "I don't need to explain myself." "I need your ID." "Actually, you do," Whitaker replied. "The Fourth Amendment requires specific, articulable facts. A vague report isn't enough." Reynolds' jaw clenched. "You're being uncooperative." "No," Whitaker said evenly. "I'm asserting my constitutional rights." "That is not obstruction." A few shoppers slowed as they passed, sensing the tension. One woman stopped near the storefront and quietly raised her phone, the camera pointed in their direction. Reynolds noticed and stiffened. "This isn't a debate," he said. "Step away from the vehicle." Whitaker paused, calculating risk rather than pride, knowing how quickly situations like this could turn. "I will comply under protest," he said. "But I want it clearly stated that this detention lacks reasonable suspicion and violates my Fourth Amendment rights." He narrated his movements as he reached into his jacket. "I'm retrieving my wallet." He produced his driver's license and held it out, waiting. Reynolds took the license and studied it longer than necessary, his eyes flicking between the name and Whitaker's face as if searching for inconsistency. "This your car?" he asked. "Yes," Whitaker replied. "And I can demonstrate that if needed." Reynolds tilted his head. "Go ahead." Whitaker lifted the key fob from his open palm and pressed the lock button. The Lexus lights flashed, and the doors clicked shut. He pressed it again and the locks released. "Satisfied?" Whitaker asked. Reynolds should have ended the encounter right there, returned the license, and walked away. There was no crime, no discrepancy, no justification left. But the stop had drawn attention. 2 people had slowed nearby. The woman with the phone was still recording. Reynolds felt the pressure of being watched and made a choice. "You're being belligerent," he said. "You need to stay right here while I verify this information." "On what legal grounds?" Whitaker asked. "I've provided identification and proof of ownership." "Am I being detained?" "Yes," Reynolds replied. "For an investigation." "An investigation into what crime?" Whitaker pressed. Reynolds didn't answer. He turned and walked back to his patrol car, Whitaker's license still in his hand. Whitaker remained beside the Lexus, posture calm, hands visible, silently tracking the seconds. He glanced toward the woman filming and gave a small nod, encouraging her to keep recording. Reynolds ran the license. Clean record. No warrants. The registration matched perfectly. Everything confirmed what should have been obvious from the start. Reynolds sat in the cruiser longer than necessary, staring at the screen, knowing he had nothing and realizing backing down now would mean admitting he never should have stopped Whitaker in the first place. Reynolds stepped out of the patrol car with Whitaker's license still in his hand, his posture rigid, his tone sharper than before. "Sir," he said, "I'm going to need to search your vehicle." Whitaker's expression didn't change, but his eyes focused. "On what basis?" he asked. "I have reasonable suspicion there may be stolen merchandise inside." Whitaker exhaled slowly. "Based on what specific, articulable facts?" he replied. "Every bag in that trunk is from this mall, and I have receipts." Reynolds hesitated, then said, "Your behavior is suspicious." Whitaker shook his head slightly. "Asserting constitutional rights does not create reasonable suspicion," he said. "You cannot bootstrap my refusal to consent into probable cause. That principle is clearly established." Reynolds' face flushed. "Are you a lawyer?" he asked. "I am," Whitaker replied, "and I've spent my career litigating cases exactly like this one." The tension around them thickened. More shoppers had stopped. The woman recording had moved closer. Another phone appeared from across the lot. Reynolds looked around, then back at Whitaker, realizing the encounter was no longer contained. "You need to cooperate," Reynolds said. "I am cooperating," Whitaker replied calmly. "I've provided identification, proof of ownership, and I'm standing still. What you're doing now is prolonging an unlawful detention." Reynolds didn't respond. He looked at the car, then at Whitaker again, as if searching for any excuse to regain control. Instead of de-escalating, he tightened his stance and raised his voice. "Turn around," he said. "Step away from the vehicle." Whitaker held his ground. "Officer," he said quietly, "this is the moment you should stop." Reynolds took a step closer, his voice louder now, sharpened by frustration and the presence of witnesses. "Sir, turn around and place your hands behind your back." Whitaker didn't move immediately. He looked at Reynolds steadily. "Before you do this," he said calmly, "you should understand that you have no legal basis to arrest me. There is no crime, no probable cause, and no lawful investigation." Reynolds didn't answer. "If you proceed," Whitaker continued, "you are creating personal liability. Qualified immunity will not protect you when the law is this clearly established." Reynolds scoffed. "You don't get to lecture me," he said. "You're interfering with an investigation." "There is no investigation," Whitaker replied. "There is an officer acting on assumptions." Reynolds reached for his handcuffs. The sound of metal clicking echoed faintly in the parking lot. The woman filming said quietly, "This is all on video." Reynolds ignored her. "Turn around," he ordered again. Whitaker exhaled slowly, understanding the calculation Reynolds had already made. Pride had replaced judgment. "I will not resist," Whitaker said. "But understand this moment. You are arresting an innocent man for asserting his rights." He turned deliberately and placed his hands behind his back. The cuffs closed around his wrists, cold and tight. A few people gasped. Someone muttered, "This is crazy." Whitaker stood still as Reynolds guided him toward the patrol car. He didn't struggle. He didn't argue. His mind was already moving ahead, cataloging timestamps, witnesses, camera angles. As he was placed into the back seat, Whitaker looked up once more. "This stop," he said quietly, "will not end the way you think it will." The drive to the station was silent except for the low hum of the engine and the occasional radio chirp that Reynolds didn't respond to. Whitaker sat upright in the back seat, wrists cuffed, eyes forward, mentally reconstructing the encounter second by second. Reynolds gripped the steering wheel harder than necessary, replaying the moment he decided to arrest instead of walk away. At the station, Whitaker was escorted inside, drawing brief glances from officers who assumed this was routine. He was seated in the processing area where a booking officer began the standard procedure, removing personal belongings one by one. When Whitaker's wallet was opened, the routine stopped. The officer's eyes paused on a credential tucked neatly behind the driver's license, heavier than plastic, edged with an official seal. She pulled it out, read it once, then again, slower this time. She looked up at Whitaker, then at Reynolds. "Where exactly did you arrest him?" she asked quietly. "Parking lot," Reynolds replied. "Suspicious person call." The booking officer didn't argue. She stood up and walked toward the supervisor's office without a word, the credentials still in her hand. Whitaker remained seated, calm, patient, listening as Reynolds shifted his weight behind him. For the first time since the encounter began, Reynolds felt something unfamiliar settle in his chest. Uncertainty. He glanced toward the hallway where the booking officer had disappeared, then back at Whitaker, who met his eyes without expression. The balance in the room had changed, and Reynolds could feel it, even if he didn't yet understand how badly. The supervisor arrived moments later, a lieutenant with decades on the force whose expression shifted the instant he saw the credential. He took it from the booking officer, examined the seal, the photograph, the signature, then looked directly at Whitaker. "Mr. Whitaker," he said carefully, "can you confirm your full name and date of birth?" Whitaker did so without hesitation. The lieutenant nodded once, already knowing the answer before it came. He turned to Reynolds, lowering his voice. "Did you verify this before the arrest?" Reynolds hesitated. "I thought it might be fake." The lieutenant exhaled slowly, the kind of breath that comes when damage is already done. "It's not fake," he said. "And you arrested a federally recognized civil rights attorney with a documented litigation history against law enforcement." Reynolds' face drained of color. "Sir," the lieutenant continued, "do you understand what that means?" Reynolds didn't respond. The lieutenant turned back to Whitaker. "You are being released immediately," he said. "Your cuffs will be removed, and your property returned." Whitaker nodded once. "I want copies of everything," he said. "The call report, body camera footage, dash footage, and every written statement associated with this arrest." The lieutenant didn't hesitate. "You'll have them," he replied. As the cuffs were removed, Whitaker stood, rolling his wrists slightly. He looked at Reynolds for the first time since entering the station. "This didn't have to happen," Whitaker said quietly. "But now it will be examined in detail." Reynolds said nothing. The room was silent except for the distant sound of phones ringing, a reminder that consequences had already begun moving forward. Whitaker was escorted out of the station without ceremony, his belongings returned, no paperwork offered beyond a quiet apology that avoided eye contact. The night air felt colder than it should have as he stepped onto the sidewalk, the sound of the station doors closing behind him marking the end of the detention and the beginning of something much larger. He didn't go home. He sat in the back of a rideshare, phone already in his hand, making calls with the same calm precision he had used in court for decades. The first call went to a colleague who specialized in constitutional litigation. The second went to a legal advocacy organization he had worked alongside for years. By the time he arrived home, the incident report had already been requested, preservation letters drafted, and body camera footage legally locked from deletion. By morning, internal emails were circulating inside the department. By noon, the chief's office had been briefed. Reynolds was pulled from patrol pending review, his badge and weapon logged, his name suddenly appearing in databases he had never worried about before. Surveillance footage from the parking lot was flagged and copied. Civilian phone videos began surfacing, each angle adding clarity rather than confusion. The narrative Reynolds had relied on collapsed frame by frame. There was no resistance, no threat, no suspicious behavior, just an older man standing beside his own car. Whitaker watched the footage once, then turned it off. He didn't need to relive it. He knew exactly what it showed. By the end of the day, what had started as a routine stop had become a legal exposure the city could not contain quietly, and everyone involved understood that silence was no longer an option. By the end of the week, the story had escaped internal channels and reached the public. Local media picked it up first, then national outlets followed, each headline sharper than the last. Video from the parking lot spread rapidly, shared millions of times, dissected frame by legal analysts and former officers who pointed out every violation in real time. Comment sections filled with people recounting their own experiences, many eerily similar, most without the outcome Whitaker received. Under mounting pressure, the department opened a formal internal investigation, assigning senior investigators to review the stop, the arrest, and Reynolds' prior conduct. The findings were unambiguous. The original call cited no specific crime. Reynolds had initiated the detention without reasonable suspicion, extended it beyond any lawful duration, and escalated it into an arrest solely based on Whitaker asserting his rights. Data analysts uncovered a broader pattern as well. Reynolds' stops disproportionately involved black motorists and pedestrians, with search and arrest rates far exceeding departmental averages. The footage, combined with the data, left no room for interpretation. What had happened in that parking lot was not an isolated mistake but a symptom of unchecked bias. As the report circulated through command staff and city officials, the tone shifted from defense to damage control. Meetings became urgent. Lawyers stopped asking how to fight the case and started asking how much it would cost, because everyone involved understood the same thing. This wasn't just embarrassing. It was indefensible. The outcome came swiftly once the facts were undeniable. Reynolds was terminated for cause, the decision citing unlawful detention, unlawful arrest, and violations of constitutional policing standards. His appeal went nowhere. The footage was too clear, the timeline too precise, the evidence too complete. The city moved to settle Whitaker's lawsuit before it ever reached a jury, agreeing to a substantial payment and a series of mandated reforms that would be monitored for years. Policy changes followed, then training requirements, then oversight mechanisms that hadn't existed before the arrest ever happened. Whitaker returned to his life quietly, declining interviews and refusing to frame himself as a victim. In a brief statement released through his attorney, he said only that accountability matters most when it's uncomfortable and public. The footage continued to circulate, shown in training rooms, classrooms, and community meetings as an example of how quickly authority can slide into abuse when assumptions replace evidence. For many viewers, the story wasn't shocking because of who Whitaker was, but because of how ordinary the moment had been before it escalated. An older man, groceries, a parking lot, and a decision that changed multiple lives. Whitaker later said the most disturbing part wasn't the arrest itself, but how routine it felt until it went wrong. He knew countless others had experienced the same thing without cameras, without credentials, without leverage. This time, the system was forced to respond. And that response became the real story. In the months that followed, the case became a reference point far beyond the city where it happened. Law schools used it to teach Fourth Amendment limits, showing students how quickly an encounter becomes unlawful when an officer cannot articulate facts. Police academies studied the footage as an example of escalation driven by ego rather than evidence. Community groups played the video at town halls, pausing at key moments to ask a simple question: at what point should this have stopped? Whitaker never appeared in those rooms, but his presence was felt in every discussion. He understood that the power of the incident wasn't his identity, but its clarity. There was no ambiguity, no chaos, no split-second danger, just a chain of choices made in full daylight. The department issued public statements acknowledging failure, but Whitaker focused on something else entirely. He pressed for transparency and stop data, early warning systems for repeat patterns, and independent review with real authority. These were not symbolic fixes, they were structural ones, designed to catch problems before another parking lot encounter spiraled out of control. For Reynolds, the story ended quietly. No press conference, no redemption arc, just a personnel file that closed the door on his career. For the city, the story lingered as a reminder that public trust, once broken, is expensive to rebuild. And for Whitaker, the incident reinforced the truth he had argued for decades. Constitutional rights only matter if they are enforced in ordinary moments, not just in courtrooms. As the footage continued to circulate, something unexpected happened. Officers from other departments began reaching out privately, not to defend what happened, but to admit how familiar it felt. Whitaker received messages from retired patrol officers who said they recognized the moment Reynolds doubled down, the instant when admitting a mistake felt worse than creating a bigger one. Civilian oversight boards cited the case when pushing for expanded authority, arguing that accountability cannot depend on who gets stopped. The city implemented periodic audits of stop-and-search data, not as a temporary response but as a permanent requirement tied to command evaluations. Training manuals were rewritten to emphasize disengagement as a professional skill, not a loss of control. Whitaker watched these changes from a distance, rarely commenting, never claiming credit. He knew reform was fragile and easily reversed if treated as a public relations exercise. What mattered was that the incident had stripped away plausible deniability. No one could argue confusion or threat when the evidence showed calm compliance from start to finish. The parking lot became a case study in how power operates when unchallenged and how quickly it retreats when documented. Whitaker later said the most telling detail wasn't the arrest or the settlement, but how many people told him they were surprised accountability actually happened. That surprise, he believed, revealed the real problem. When consequences feel rare, misconduct feels safe. And when misconduct feels safe, it becomes routine. Over time, the story stopped being about one officer and became a mirror held up to the system itself. Analysts pointed out that nothing extraordinary had triggered the stop, no emergency call, no imminent danger, just a vague report and a decision made without scrutiny. Whitaker emphasized that this was precisely why the case mattered. Extraordinary abuse is easy to condemn, but ordinary misuse of authority often passes unnoticed. He spoke privately to lawmakers about the danger of treating constitutional violations as technical errors rather than human experiences. Each unlawful stop carries fear, humiliation, and risk, even when it doesn't end in handcuffs. The city's settlement agreement included language acknowledging harm, not just liability, a detail Whitaker insisted on. He wanted the record to reflect that rights violations are not harmless mistakes. As months passed, the footage lost its shock value but gained permanence, resurfacing whenever similar incidents occurred elsewhere. Journalists referenced it. Advocates compared timelines. Officers were asked why their encounters didn't end sooner. Whitaker believed that was the real legacy of the moment in the parking lot. Not punishment, not money, but memory. A documented reminder that authority must justify itself continuously, not just after harm is done. Because once people stop expecting explanations, power stops offering them. Whitaker often reflected on how narrowly the outcome had depended on documentation. Cameras, witnesses, and a paper trail had turned what could have been dismissed as a routine stop into an undeniable record. He knew that without those elements, the story would likely have ended differently, reduced to conflicting statements and assumptions given the benefit of the doubt. That understanding shaped how he spoke about the incident when asked privately. He never framed it as a personal ordeal, but as an example of how fragile accountability can be. Systems do not fail loudly, he said, they fail quietly, one unchallenged decision at a time. The parking lot encounter forced an interruption in that pattern, not because it was unique, but because it was visible. Visibility changed the balance. It shifted the burden from the person being stopped to the person exercising authority. Whitaker believed that shift was the most important consequence of all. Policies could be rewritten, officers disciplined, settlements paid, but without visibility, none of it lasts. What endures is the expectation that power must explain itself, justify itself, and withstand scrutiny in ordinary moments. As long as that expectation remains, the incident serves a purpose far beyond the individuals involved, standing as a quiet warning that routine encounters can carry extraordinary weight when the law is ignored. In the end, what stayed with people wasn't the title Whitaker carried or the legal consequences that followed, but how ordinary the moment had been before everything went wrong. A parking lot, groceries, a brief exchange, and a decision that exposed how easily authority can override reason when unchecked. Whitaker often said the incident confirmed something he had argued for years in court. Constitutional rights are most vulnerable in everyday encounters, not dramatic ones. They depend on officers choosing restraint when nothing forces them to, and on systems willing to act when those choices fail. The reason this story mattered wasn't because accountability happened, but because so many people were surprised that it did. That surprise revealed how low expectations had become. Whitaker hoped the footage would remind people that rights are not abstract concepts reserved for courtrooms. They are meant to function in parking lots, sidewalks, and ordinary moments of life. If the story changed anything, it was the assumption that nothing would happen afterward. Accountability did happen, but only because the moment was seen, recorded, and remembered. That is why stories like this need to be told, not to shock, but to document reality as it is. If this made you think differently about power, accountability, or everyday encounters with authority, make sure you subscribe for more stories like this, because these are the moments that shape how systems change, and they only matter if people keep paying attention.